Good morning. I'm glad to see such a full room of everybody prepared to be called on and to participate. The format of the panel will be, you're going to see something unusual this morning. You're going to see 5 members of the Harvard Law School faculty who have each been allotted 5 minutes for an opening. Keep to that format. That never happens, but it's my job to see that we keep to the schedule. And then the plan is to open it and to have a discussion with you. This is the one panel today that is really focused on probably the biggest problem that the legal profession faces. The fact that most people in this country don't have access to justice. And the program has, in my view, it has 2 pieces to it. One is the profession's problem, and the second is the law school's problem. And the first problem, I think, is obvious to all of us. Most people in the United States don't have access to lawyers. The second problem is one that has developed. And I've been here a long time, more than a quarter of the history of the Harvard Law School, and I've watched it develop. In my class, there were 1,100 applicants, 800 got admitted, and 525 came. We were not all alpha personalities, and we looked at a profession where the big law firms, except for one, were about 50 or 60. And so in my class, 1 or 2 went to Cravath, 2 went to Davis Polk, 2 went to Sherman and Sterling, and you can do the math. People went everywhere. They went all over the country, and they didn't go just to the big cities. They went to the small towns. And I have a piece, this is Exhibit A. Some of you who've been around a while will recognize this. The Harvard Law School Alumni Directory, which used to be put out in hardcover. And this is the last one that has appeared in this century. And it has in the back a geographic section where our alums are divided by countries and by states. And if you look, and then within each state, they're divided by all the places where our alums practice. Cities, small towns, villages. And if you open it, you can look at any state in the United States. And in almost every, not just city, not just town, but village, you'll find a Harvard Law School alum. The problem is that in this last one, once you look out of the big cities, all the alums are in their 60s, 70s, and 80s. So when I graduated, you wouldn't talk about the problem of our Harvard Law School alums going everywhere in the country and serving all kinds of people in all kinds of communities. It just happened. Starting salaries in New York when I graduated law school were $3,600. In Boston, it was $2,400. And you can put any multiplier you want to that, and you won't get anywhere near starting salaries today, or any standard of living multiplier. And the measure used to be federal judges. People looked at those salaries and then looked at the salaries of what they were likely to earn in the job where they were. And they weren't far off. If you talked about hedge funds in those days, you were talking about, I don't know, a landscape company, maybe. There was no such comparison. And I think if you just state those facts and then look at where we are today, you see the problem, and you see the problem for the Harvard Law School. You know, whom are we educating, and for what, and for what kind of service? And the needs of people at the lower ends of the income spectrum have probably multiplied in the same way salaries have multiplied. The regulatory state has just vastly increased the need for lawyers. And so as we face the third century, the profession has got a problem, and I think the law school has got a problem. What are we doing, and for whom? And it affects everything we do here, starting with admissions, going right through curriculum, and then to our career services operation. And that's the subject of today's panel. And to my left, we have Todd Rakoff, who will talk about this from the educational side, the curriculum side. And to my right, Dean Minow, who will talk about it from many different sides, but hopefully from, in part at least, her work as vice chair of the Legal Services Corporation. To my left, Jim Greiner. I'm sorry he didn't bring his pet robot with him, the experimental robot that's going to replace all lawyers at some point in this century.
I do have a laptop, which will serve much the same function. Yeah.
He will talk to us about the problem from the point of view of how technology can be part of the solution. And from the trenches, on my right, Brian Price, who is the head of all our transactional clinics. And that's another part of the solution. And I think I've used up my 5 minutes. And Todd?
All right. So I read somewhere that 80% of the American public considers itself middle class, which is an American way of saying ordinary. Ordinary people have lots of ordinary problems that would benefit from the advice a lawyer could give them. All right? They are making a will. They are starting a small business. They are being asked to sign a piece of paper from their employer that has lots of covenants on it. They are being charged with operating under the influence. They are going through a divorce where child custody is being contested. They have a child who needs a special educational program at a local school. They are buying a house. They are trying to collect a disability benefit. They have a consumer complaint. They can't pay their debts when they come due. But these kinds of needs may not be worth spending the kind of money a lawyer might charge, or even if they are worth spending the money, the people who have these needs may not have the money to spend. So we have to ask, what can Harvard Law School do about that? One thing we have done, and I don't want to let this pass, one thing we have done is to greatly increase the amount of pro bono effort that our students contribute, both in our clinics and through our mandatory pro bono obligation. And I want to add thanks to the two people directly to my right, your left. Professor Kaufman, who was the moving force behind our having a mandatory pro bono program, and Professor Dean Minow, who in her years as deanship greatly increased our clinical efforts. But while the poor which is what the pro bono effort is especially directed towards, need all the help they can get, I am skeptical of the suggestion that the legal deficit of the middle 80% will be cured by throwing more lawyers at it. There are lots of lawyers in this country. And as I have just suggested in my list, there's a lot of implicit demand for legal services, but the market is not succeeding in bringing them together. And if we go outside of the market, in a country that can't even agree on spending the amount of public money needed to make sure that everybody has basic medical care, we're not going to spend it to make sure that everybody has legal services. So I think we have to ask ourselves what means besides providing a lawyer might be used to provide legal advice for these ordinary problems of life. And as Andy has correctly said, that immediately also brings up the question, what role does HLS play in that, answering that question? So one possibility is to work to strengthen the ability of people to represent themselves. Pro se representation in court is much more common than I realized till I started looking into this, and maybe than you realize. It was recently reported that in more than 3/4 of all the civil trial cases filed in the United States, at least one party does not have a lawyer. And of course, pro se representation must be even greater in the legally tinged transactions and disputes that happen outside of court. Now, there are a lot of experiments going on how to aid people doing things pro se, over the internet especially, both in terms of providing legal documents and in terms of providing legal advice without legal representation. I leave the question of the extent of the bar's monopoly to somebody else to worry about. I want to point out the educational side of this, which is thinking like a lawyer, what we teach, involved in efforts of this sort seems to me very different from the type of thinking like a lawyer that we most commonly teach now. Right? And just to give two particulars, in ordinary classes, I teach contracts. I teach contracts in this very room, and the highest form of argument in an ordinary class is to be able to persuade a judge. Right? And that's a very different task from explaining something to a layperson, and especially from explaining something to a layperson who is then going to go and operate with that advice to do something for herself. Similarly, in our ordinary classes, being subtle is usually considered to be a positive attribute. That's very different from prizing the simplicity in the law or the simplicity instructions that might be needed if you're helping people handle things for themselves. So, in short, if our goal is to enable our students, to enable ordinary people to avoid what I might call self-help malpractice, we may need to equip our students with a different set of skills and attitudes from what we're doing right now. As an alternative, or perhaps in addition, we could get into the business of preparing classes of practitioners of legal services that are neither untrained laymen nor full-fledged attorneys. This would acknowledge the fact that what people need is not just advice but representation as well. And the medical profession, it seems to me, has gone pretty far in this, in empowering nurse practitioners to do quite a lot of stuff on their own. But in the legal profession, by and large, we've handled paralegals the other way. We made them institutionally subservient to full-fledged attorneys for everything they do. The state of Washington is currently experimenting with something they're calling limited licensed legal technicians, LLT, who are handling out-of-court family matters as independent practitioners. And we could, at Harvard Law School, make a real social difference, I think, if in addition to our JD programs and our LLM programs, we got behind a program to offer a 9-month or 12-month certificate for people who would be able to do less than the lawyers we train now, who would only be trained for and certified for particular types of matters, but who could do much more than nothing and would be more likely to fulfill the market need that the people we're graduating now are not fulfilling. Obviously, this would require working with the organized bar, as well as being innovative educationally, but it might serve the public need very well. I think that's my 5 minutes.
It's just a pleasure to see you all here. If there's an empty seat next to you, would you raise your hand so the people who are standing can see where they can go sit? Great. So I'm going to spend my 5 minutes to highlight the crisis in access to justice with a focus on civil matters and poor people. So domestic violence, eviction, veterans benefits, child custody, these are issues that are life and death or near to it for people, and yet, without lawyers, they are really in trouble, and they don't have lawyers. And it's neglected in the headlines, or the blogs, or the tweets, and we have a shameful, shameful crisis in a country that claims to be committed to equal justice under law. Our justice system is inaccessible to millions of people every day. And Americans who can't afford legal help forfeit their basic rights because rights are not self-enforcing. Veterans who seek benefits, victims of natural disasters, domestic violence survivors, tenants and homeowners. People need advisors and guides or someone to cut through the bureaucracies, the laws, the agencies, the courts, and the dangers that they encounter in their daily lives. For criminal matters, I'm not going to talk about it, but I don't know if you know. Gideon versus Wainwright, great case, wonderful book, very good movie. It's actually not realized in America. We do not have access to counsel for people who face jail time in this country. And even the communities that provide something called a public defender charge for it, charge poor people for it. So we don't have it. So, but that's another subject. Maybe we'll talk about it in the discussion. I'm going to focus on civil. Todd Rakoff explained that 3/4 of people in this country who end up in court in civil matters are unrepresented. The judges that I talk with around the country describe this as being on a highway with a broken down car because they can't manage the rest of the cases, not even to mention what happens to the individuals who are caught in the legal system without representation. The average hourly billing rate right now, many of you here will know better than I do, but the average in the country is $284. But when I say average, it reminds me that when my daughter was born, the average child, I was told, slept 12 hours a day. We had a neighbor whose child had to be awakened to feed, and I had one who did not sleep. So that's what you can learn about averages. For HLS grads who go to a large firm right after graduating, it's $500, $600, $800 an hour. And, a couple years out, it's quite a bit more. Across the country, nonprofit organizations and private law firms offer civil legal help to people with limited incomes, whether it's sliding scale or pro bono. I am, as Andy said, vice chair of the bipartisan Federal Legal Services Corporation, which distributes grants from the federal government to 133 grantee organizations across the states and the territories, including Puerto Rico and the 2 offices that are completely destroyed by the hurricanes. And when this bipartisan effort started in 1974 under, actually, President Richard Nixon, who looks pretty good at this moment, with legislation that authorized provision of free civil legal assistance for people who fall below the poverty level or at 125% of the poverty level. At that time, 12% of the population was qualified. And due to increases in poverty levels at this time in this country, over 18% of Americans are now eligible. And yet the federal contribution has dropped during that time. So in inflation-adjusted dollars, it's $204 million less per year now than it was in 1978. And the problem is not remote. Low-income people who are denied their legal rights live around the corner from you. And it is a catastrophe. I've been to Indian reservations where just being able to access veterans' benefits is impossible. There is something going on in this country that most people don't understand. And there's poverty and disasters around the world, but this is supposed to be the richest country. This is supposed to be the country that represents rule of law. Today in the Boston Globe, there's an op-ed by Chief Justice Ralph Gantz, graduate of the Harvard Law School, who declares a state of emergency in Massachusetts because of the lack of representation for people facing child protection hearings, loss of a child, what could be more disastrous, and child custody matters. Even with rising contributions by state and local bar associations and law schools in pro bono, and even with the innovations like the IOLTA funds, the interest on trust accounts that are held by lawyers while they are representing clients, with declining interest rates, that's basically plummeted to almost nothing. And even with the technology innovations and the partnerships with courts and libraries, the gap is, I think, based on a most recent study commissioned by the Legal Services Corporation, but done independently by the University of Chicago, we think that between 1/4 and 1/2 of all the people who are eligible for legal services are turned away. And those are the people who make it to the doors of an office. This is not even describing the people who don't make it there. Massachusetts was one of many states that commissioned studies to figure out what are the dollar benefits of providing a lawyer for a poor person. Massachusetts, we found that actually between every dollar spent returns between $4 and $5 back to the Commonwealth. Why is that? Because you have savings in foster care, you have savings in emergency housing, savings in emergency health, savings in other social services when people actually have preventive legal help. And yet, this kind of money case has not succeeded in most places. It did succeed a little bit in New York. So Chief Judge Jonathan Lippman, when he was Chief Judge, conducted a similar study in New York and persuaded the New York legislature to increase the funding of civil legal assistance up to $70 million a year, but it isn't happening in most parts of the country. There are religious organizations and other organizations that are pitching in places like Tennessee to meet the needs of low-income people. And there are innovations that I hope more people on the panel and in the room will discuss. But I want to just put a face on the problem. So Yu Chu Heng was a senior citizen, relying on fixed public benefits, rented an apartment for over a decade in San Francisco and Chinatown. His landlord raised the rent beyond the limits set by law in the city. He went to the legal services provider, which represented him, and awarded him $12,000 in excess payments. But someone next to him didn't get the services and ended up not being able to pay and ended up being evicted. Garrett and Jarrett were born prematurely to a homeless mother who used methamphetamines during pregnancy, and their 2 children experienced severe developmental delays. And their adoptive parents tried without success to get early intervention services, and they turned to a legal aid organization, which did get them access to physical and occupational therapies, and with that help, the boys are now on track. There are at least as many families not getting those services as there are families getting the services. So I have tried using facts, I've tried using the business case, I've tried using historical legacy arguments, I've tried using shame, international comparisons. It's very hard to get anyone to care about this issue. And I am most interested in what would it take for people to care about this issue? What would it take for lawyers to care about it? What would it take for a larger community to care about it? I have great quotes. I can give you stirring quotes from Justice Lewis Powell, stirring quotes from Chief Justices around the country. It hasn't worked. And so I think we could and should revisit the unauthorized practice rules. As Todd suggests, we should expand the uses of technology. The Legal Services Corporation is one of many places that is experimenting with the kinds of work that Jim Greiner will tell us more about, that try to bring the tools of artificial intelligence and other kinds of technologies to help self-represented people or even to facilitate legal representation. They're not giving someone of the talent a Brian Price. They're not giving someone the personal attention and strategic thought. And I just will close by saying then there's law reform. Because how many of the legal problems arise because the law is a mess? Look forward to hearing from you all.
Jim.
So I want to share two thoughts with you as we figure out how to address this problem. Martha has very ably focused us on what works in terms of an outward-facing message. How do we get people to focus on this issue and care about it and invest resources in it? I want to also suggest that the what works question can be turned inward. When we face a problem of this magnitude, one instinct is to do what we do with all humongous problems. Let's try to innovate. Let's try to come up with new things. Let's try to figure out what we can do that we haven't done before. I think that's an absolutely understandable and correct instinct. My suggestion to you today, though, is that we have been innovating well for the past 3 decades. We have come up with all sorts of solutions that were not in the traditional attorney-client relationship model of, say, 5 or 6 decades ago. Todd has mentioned one, the limited license legal technician, the LLT. There are numerous others. There are programs that Andy has referred to, artificial intelligence programs that can create guided interviews and with simple matters spit out answers that are actually extremely accurate and adapted to particular localized jurisdictions. There are market-based solutions for people who have affirmative claims, but affirmative claims that are not of a magnitude that would justify filing their own lawsuit. Those market-based solutions might be anything from aggregation techniques to the revocation of legal rules that prohibit selling a claim and thereby aggregating it using a market. There are service-based solutions that can be partially market-based, again, the LLT, or non-market-based. Those are the traditional attorney-client relationships, or what 80% of LSC-funded entities provide to their clients, non-full attorney-client relationships, limited service and advice. There are non-market-based solutions entirely, self-help materials, and non-service-based solutions, self-help materials, again, the artificial intelligence. What I want to suggest to you is that what we may face is not just a lack of ideas, or perhaps even not a lack of ideas at all. We may have a large number of ideas, but we're missing 2 things at least in the solution generation portion of our efforts. One is a recognition that we in law were not first in any of these problems. If they're broken down structurally and stripped to their essence, other professions, other areas of thought have faced precisely these problems and have been working on them longer than we have. And the second is other professions and other areas of thinking have invested resources that we have never invested in finding out what works and what doesn't. So let me talk about the first one for a second. What is it that other professions have done before we have gotten there? If you think about self-help materials, for someone who is encountering a legal problem and who hopes to encounter that legal problem only once or at minimum twice, say getting a divorce, one hopes not to have to do that more often than once or twice. The issue is not, can we educate that person about divorce law? At least not for that individual. That individual has no interest in learning about divorce law. That individual has a particular goal, a particular task. I don't want to be married anymore. And to that individual, it is about as interesting as building an IKEA bed, which I did once unsuccessfully. It broke while I was on it. I'm not an idiot. I concluded that it actually was, when I went back and diagnosed what happens, it was a problem with the instructions I had been given. The problem then was that the IKEA folks' bed construction department had not reduced the problem to its essence and then used what we know about adult education, graphics, simplified language, design on the page, using accessible words, etc. All of these things that go far beyond simplified language, which is what everybody in law wants to think about, is enough. It's not enough. People interact with text, non-lawyers, I should say, interact with text differently from lawyers do. They want graphics, they want images, they want instructions, they want reinforcement, they want attention to psychological states. It's a depressing thing to construct an IKEA bed. I need encouragement from my IKEA instructions as I go along. We may need to learn from all that we know from fields in adult education, sociology, psychology, behavioral economics, statistics. These are all fields that have encountered problems structurally identical to the ones that we're encountering in law before. But because we are lawyers and because we are exceptionalists, the legal profession is exceptionalist, we feel like we have to reinvent every wheel. The LLLT idea is precisely original as a shoe. It is an application of the paraprofessional that the medical profession has used for decades and has empowered for decades. We do not need to reinvent every wheel. There's a lot we can learn. Second thing that we can learn is perhaps a meta idea. We can take from other professions something that we currently don't do in law, and that is find out what works. We should judge the effectiveness of an innovation or indeed a current practice not by how cool it sounds, not by how many whizzes and bangs it makes, which is what everybody loves about technology. It sounds so cool, and by the way, it is really cool. It's amazing to use one of these artificial intelligence programs and give it a legal problem and have it spit out an answer more complete and more accurate than a typical lawyer would know off the top of her head. It's incredible. It is precisely of zero use to somebody who can't access that technology, who doesn't have the smartphone or doesn't have the computer access or can't find the location. How do we figure out whether these innovations, of which there are dozens upon dozens upon dozens, actually work? There are well-established research methods that do this. The gold standard is the randomized control trial, which is what I dedicate my entire life to, doing randomized control trials in the legal profession. There are other research techniques that also show what works and what doesn't. The application of them requires that we be clear about what goals we want to achieve. Do we want to get the person, do we want to avoid a judgment of eviction in an eviction court? Or do we want to have the individual defendant still in the apartment unit 6 months or 8 months or 10 months after the eviction case? Those are two entirely separate things. We as lawyers focus on the adjudicatory output of the proceeding, or we focus on whether the person was treated with dignity and respect in the courtroom. Those are important goals. But when a client comes into your office as an eviction lawyer, do you think the client is asking, I want to avoid a judgment of eviction? Or do you think the client is asking, I want to stay in my apartment unit? Which of those two things is the more important thing? Again, sometimes if the client is on public benefits, on Section 8, the judgment of eviction is a 3-year death sentence. On other instances, it's can I stay in the apartment, and that's all I care about. And as much as I care about, and I do, care about procedural justice, as much as I care about the folks who study in that area, I have not heard yet of a client, a potential client who walks into a law office and says, I'm looking to have a very good experience in court while I'm there. I just haven't heard that person. They are important values, but we need to recognize what they're for. They're for rule of law generally. They're not for this, maybe not for this particular client. And so 2 messages then in terms of to leave you with. Innovation is important. We need to continue it, but it may not be a lack of innovation that we're suffering right now. It may be an attempt to reinvent every wheel on the solution side and a lack of attention to figuring out what works and what doesn't.
Brian,
So,
you're on.
so my work here at the law school focuses on teaching students transactional law through the transactional law clinics. So we practice in the small business area, nonprofit area, community economic development area. And so the clinics are called the Business and Nonprofit Clinic, the Real Estate Clinic, Entertainment Law Clinic, Community Enterprise Project. Also under the TLC umbrella are the Recording Artists Project and the Harvard Law Entrepreneurship Project. Those are student practice organizations. So in the TLC clinic, we roughly will educate about between 50 and 60 students per academic year. The Recording Artists Project, roughly about between 60 and 80 students per year. In HLEP, roughly about between 125 and 150 students a year. So the mission in TLC is twofold. Obviously, we're at a law school, so we want to educate students. Secondly, the other part of the mission is to provide access to quality legal services to those who otherwise might have difficulty attaining those services. In addition, to provide services to individuals, organizations who might themselves provide assistance of some sort, whether services or goods, to disadvantaged communities or individuals. So the work that we do is pretty broad in TLC. Harvard Law School, because of the resources that we have, we're able to do a lot of different things. So for small businesses, for instance, we'll help them with entity formations. We'll help them to access capital either by assisting them with loans or assisting them with equity issuances. We help with commercial leases, contracts, intellectual property like copyright and trademark, acquisitions and sales, tax-exempt applications, so a litany of different kinds of things. Transactional legal services are very expensive on the open market. At the low end, roughly, a person might spend a couple $100 an hour. At the upper end, $1,000 plus per hour. So many people who need transactional services are going to forego legal assistance because their legal needs are more pressing in other areas of their lives. And so, for example, to do an entity formation in the private market will cost somebody a couple $1,000s. For us, we'll do it pro bono or low bono, and we kind of work on a sliding scale. Micro enterprises are businesses that have 5 or fewer employees defined by the SBA, or may have startup needs of $35,000 or under. And compared to other areas of legal need that low and moderate income individuals have, there are not a lot of lawyers who, in their own economics, can afford clients, to work with clients who don't have a lot of money to spend. There's not enough money there to sustain their legal practices. So there are no government-funded programs to provide legal assistance to small businesses. It's not like other areas of law where there might, for example, in housing litigation, might be fee-shifting statutes, or in public benefits work, or like Social Security, there might be contingency payments that might be available. So that sort of stuff doesn't happen. There are not a lot of nonprofit organizations out there who are providing civil legal services to small businesses or people other transactional kinds of needs. Historically, those kind of nonprofit organizations will provide services in crisis areas, and rightly so, because there's a lot of need in those areas, as already been mentioned. Family issues, housing, public benefits, that sort of thing. Even at law schools, it's been sort of the past history about that. HLS, for example, has about 30 clinics, many of which will address those other areas that have been covered already. And so up to this point, transactional legal assistance for microenterprises, for small businesses, really have fallen on the shoulders of law schools or pro bono legal assistance. At TLC, Transactional Law Clinics, we have roughly over 500 requests every year for legal services, and we have a limited capacity, so perhaps we're able to handle about 120 to 150 cases per year. And when we started in 1997, about 20 years ago, we were one of the very few law schools that had a transactional clinic. Fortunately, over the last 20 years, the number has grown because most law schools have come to recognize that most students will wind up doing some form of transactional practice when they graduate. So right now, across the country, there are about 170 clinics that exist at about 115 schools in roughly 30 states. So we have 50 states, I think. So there's a lot of places where there's no legal services at law schools that are providing that kind of work. And you know, at these clinics, some of the clinics just focus internally on maybe providing services to their own staff or their own students or you know, other people who are constituents of the school. So there's a need there. And the kind of work that's provided varies widely at the law schools in the transactional space. Might be intellectual property, might be community economic development, might be nonprofit, but very rarely do you find a spectrum of legal services that are provided at these schools. So how does transactional legal assistance fit into this issue of access to justice? So one definition of justice says just behavior or treatment, fairness, fair play, equity, or impartiality. So in most transactions, for a just or fair shot at success, it takes access to the law. And this is knowing and understanding how the law applies to that transaction. Also, access to capital, which entails proper structuring and knowing how the law complies, and how to comply with the law and what the rules of the game are. So the gap areas for ongoing legal assistance exist for microenterprise and small businesses. Most people are flying under the radar. Most people can't afford access to the law and knowing what to do. So what happens then is they really are being disadvantaged because they don't know the rules of the game. They don't know how to legally take advantage of opportunities that might exist. For one example, we recently had a client in the clinic, and the student who worked on the case is here today, and this client is a participant in a government program that is supposed to provide advantage to disadvantaged businesses. This is an affirmative procurement program by providing access to opportunity for contracts from the government. And the stack of documents that were required was about this thick, literally. No way in the world, and this is a client who works very hard, has been at it for 10 years, no way in the world would anyone who has less fortitude, less persistence, not access to a lawyer would have been able to participate in this program. This is the 8AA program. Great program, but she needs access. She needed access to a lawyer to be able to do this. And there's just not enough access to even to take advantage of the opportunity programs. So gaps also exist in rural areas. As Todd pointed out, and I think Andy pointed out, most lawyers are going to be drawn, because of the economics, to big city life, because that's what they need to pay off student debt and so forth. Also, there's a gap in terms of small business litigation needs. We can do contracts, great contracts, but if they can't enforce the contracts, then what good are they? And it costs a lot of money to get into court. And also there's a gap between small claims court and district court and so forth. So what are some ways to bridge these gaps? Law school clinics have been doing it. But we can't do it all because of capacity issues. And there's a lot of schools that probably would love to do this, but they can't do it because of funding issues. Also, schools could help to produce and support lawyers who want to do this kind of practice area a little bit better, a little bit differently. There is things, there's loan deferment programs that perhaps could be expanded to include recent graduates who want to go into small firm practice, a solo practice, or maybe rural areas where there exists need. Also, some schools are doing postgraduate incubator programs where they're providing office space and mentoring to recent grads to help lift them after school in starting their own law school practices. But I do think it's unrealistic to think that a person who's presently engaged in private practice making a lot of money is going to want to change their standard of living. So I think we need to encourage newer lawyers and also show them opportunities that might exist to go into these other areas of practice where they can support people of lower moderate income needs where these gaps exist. But also too, pro bono efforts of private lawyers have been terrific. And I would just encourage anyone who's doing it now to continue to do it because the needs are there. And it doesn't just mean producing some documents and then letting the client go off on their merry way. It means being there, being accessible, providing help, be willing to take a phone call, really get into the interest and the needs of the client because that's what's needed. Ongoing access to the law is needed to bridge this access to justice gap.